Do you want to know that?
You'll stay later because then we've had a bit of a problem with the printer.
Oh,
So it's your
that's massive.
Just so you know, I'm going to start recording.
Silence, court rise. You in the matter of Durand McKenna Trust and the Office for Standards in Education, Children's Services and Skills and the Law.
Good morning. I appear for Ofsted, leading Mr. Sybil, Ms. White and Ms. Matu appear for the ex-school. The parties. Ofsted, as you know, is a non-ministerial governmental department set up under the Education and Inspections Act 2006. It's charged with inspecting schools, amongst other functions, and the respondent is an academy trust which was managed and maintained as an independent school called the Durand Academy. It did so under an agreement with the Secretary of State for Education, and we understand that there has been agreement between them, that is between the Durand Academy and the Secretary of State for Education, reached towards the end of August 2018 following a fairly long-running dispute between them over the manner in which the school was being run and breaches of the funding agreement. But that has now been the subject of some agreement, and the school is now renamed the Van Gogh Academy and is now maintained and managed by a different academy trust called the Dunraven Academy. And we understand that the respondent continues to exist in effect solely for the purposes of this appeal. And Ofsted, as you know, brings this appeal inter alia because, as you saw from the permission application, there were concerns that if the approach of the learned judge stood, there might be implications for future inspections. So that's the nature
Well,
of
I
this.
think the matter you just told us, I don't think we've been told before, have we?
I don't think you have.
So I'm just thinking of the judgment, I don't think I've got all of that.
Yeah.
So
Shall I
August
do it again?
2018, it's now been renamed the Van Gogh Academy,
It has.
and it's under the direction of another what?
It's under the direction of a different academy trust called
Right.
the Dunraven, D-U-N, for nanny, Raven Academy.
Right. I think that's all we need to know. Thank
As
you.
far as the background is concerned, and I can take that very quickly before coming to the legislative scheme, which I know you'll be aware of, but I just wanted to touch on a couple of bits. As far as the background is concerned, you will have seen that the dispute arises out of an inspection of the school by Ofsted on the 30th of November 2016 and the 1st of December 2016, so a two-day inspection. And the Ofsted inspectors graded the school as, quote, inadequate. The final report you will find at core file. You've got a core and a supplemental file. Core file, I'm rather hoping you might have tabs. Core file tab 14.
I know you're going to take this quite speedily, but you'll appreciate you've read all the
I
time.
am. I'm going to take it very speedily. I should have said at the outset that we've been speaking about how long we think it's going to take. I know it's listed for a day. We think we'll be done by lunchtime.
Oh, excellent.
But that's
Very good.
sort of a faint hope, but at least the hope is there. Tab 14, page 188, is the final report. And I only wish, for present purposes, just to show you the summary of the key findings for parents and pupils halfway down page 188, recording the finding that it is an inadequate school. And you see the concerns that they had after the inspection in the 8 bullet points at the bottom of that page. The detail of them doesn't matter, but just so you see the nature of those. Those are referred to in the various policy documents to which will come as the judgments. Those were the judgments reached leading to the overall judgment of inadequacy. And you will see that those grades were reached if you simply turn over the page and look at the 4 bullets at the top of the next page, 189, that those were counterbalanced by a recognition by the inspectors of some strengths that the school had. So although the overall grading was inadequate, as I say, there was a a series of judgments that were unfavourable in a nutshell, and a series of judgments that recognised strengths. Inadequate, as we will see in the statutory scheme, is the worst of 4 possible grades that inspectors could reach, and it placed the school in a formal category of concern called special measures. The consequences of a grading by Ofsted of that kind following an inspection are a matter for the Secretary of State for Education, not for Ofsted, which, as you know, is an independent inspection organisation. And the potential consequences which the Secretary of State would need to think about, having received a report of this kind, may include, for example, the replacement of governors, the termination of funding, the rebrokering of the academy, that is, the transfer of an academy from one trust to another, and so on. So those are all matters which the Secretary of State would need to consider. And the school challenged the report on the grounds of rationality, which you can see from the skeletons below, was the main thrust of at least the skeleton arguments, and, about 2 pages in each skeleton below, procedural fairness. In the judgment that was produced on the 11th of August 2017 by His Honour Judge McKenna, which is the subject of this appeal, as you will see, there was effectively a view or two offered about some of the rationality grounds, but basically no final determination of the rationality set of issues, because he concluded, as a prior point, that there had been procedural unfairness as a result of the structure.
But is that rationality challenge gone now?
It hasn't gone. There is an issue on disposal, which would arise on disposal. For the sake of argument, suppose while the court were with me on the procedural challenge, there would then be a question as to whether it is sensible or appropriate or proportionate to remit back to a first instance judge in the circumstances that now exist the remainder of the claim for rationality. But that would arise only on that disposal, I think. Well, if you were against me, then the procedural finding would stand.
You can address us on that perhaps at the end of your submission.
That's what I was proposing to do. But my Lord is right, it hasn't finally gone. But there is a question about what you would do in either of those 2 events. But you see the structure of the judgment,
yes.
No final determination of rationality, prior point on procedural fairness, and found that there was procedural unfairness, and therefore quashed the report.
Well, the procedural unfairness point, it appears, almost has 2 limbs to it. The judge below really decided as a matter of law that the structure was inadequate as a procedure. But there is also criticism by the school in its formal phase, identity, about the failure to comply with some of Ofsted's own procedures. They say, for example, feedback at the end of the day wasn't good enough, discussion with the teachers wasn't good enough, those sorts of things. Now, I don't know whether those matters are still pursued. They're not a rationality point. They go to the fairness of the procedure, in fact, as opposed to the framework.
I don't know if they are. I was going to make a couple of brief submissions about those, but they, the real thing to appreciate in relation to them is that they are 2 things perhaps. One, they are very limited challenges on the facts, and 2, no finding in the judgment either way on those complaints.
So should we just find out what the position is?
My Lord, of course.
That's what I'm quite, yes.
My Lord, they were addressed there in order to address the suggestion that my client accepted that everything was perfect in procedural terms, but there is no separate procedural fairness point run on the basis of them. It's the complaints procedure point, my Lord.
That's right. Thank you very much.
That's very helpful. So, as I say, the learned judge found procedural unfairness of a structural kind, principled kind, as my Lord has identified, and the result of that was that he quashed the report. And if you want the order quashing the report, it's in core bundle tab 7, page 57, at paragraph 3. And that prevented its publication. There had been an interim order preventing publication in the meantime, which continues to exist to this day, so this report has not yet been published. And that may be another matter to touch on briefly at the end in relation to possible disposal issues. The legislative scheme, if I could turn to that. We've set it out at paragraph 6 to 11 of our skeleton argument, and the relevant provisions of the Act, if you could take that up, are in authorities, the SLIM authorities file at tab 1, because this is the act that governed the inspection. It took place under the 2005 Education Act. And the relevant provisions, just to pick them up briefly, section 5 sub 1, duty on Ofsted to inspect and make a written report. Section 7, duty to have regard to the views of the school and parents at the time of the inspection. 2 pages on. I'm afraid the page numbers unhelpfully are numbered by section, so, but it's section 7. Duty to have regard to the views of the school and parents at the time of the inspection. Section 11, power in Ofsted to arrange for publication of reports. And there are duties, that's of course a power in section 11, but there are duties in section 14, we'll just flick a couple of pages on. In sub 1, there is a duty to ensure that a copy of the report is sent to the appropriate authority for the school. And sub 4, the appropriate authority must then, at C, take reasonable steps to make sure all parents get a copy within the prescribed period. And you might like to note next door to sub C of 4 that that period is 5 days, and that period is prescribed in the 2005 regulations, which is in the second tab of this authorities bundle, Regulation 6.
The appropriate authority for this trust was who?
Oh, it's the Secretary of State, I think. I'll check. Oh, I'm told it's the government's side.
Yes, I was trying to track down the definition section of that.
Not sure, that's in the... Oh, will you take it as governors and we'll... if it's not, we'll let you know.
I've got a feeling from the previous case I did that definition of appropriate authority isn't actually in this act.
Maybe somewhere else. We'll double check. Section 13, if you wouldn't mind going back a page or two. This section imposes extra duties where the school causes concern. And you see from subsection 1 that it only applies where the opinion of the Chief Inspector is that special measures or significant improvement is required. And here we're in special measures territory, so this is applicable. And in those circumstances, the Chief Inspector is subject to the duties set out in sub 2. Sub 2A is a duty to send the draft, that's a draft of the report, to the school. And 2B is a duty to consider any comments on the draft that are made within the prescribed period. And again, the prescribed period is 5 days. See for that purpose, Reg 5 in the regulations at tab 2. And sub 3, if the grade stands effectively, the Chief Inspector must then, quote, without delay, give a notice in writing to the Secretary of State and the school So section 13 relevantly makes specific provision for the nature and extent of the opportunity to be given to an affected school to comment on the draft of the report. And we say, as you see in our skeleton at paragraph 24, that that is a factor which tends powerfully against the courts requiring under the common law some other layer of process prior to the report being finalised. And I wanted very briefly to take you, I think they're probably the only two authorities I'm going to take you to, but I'm going to want to take you very briefly, if I may, to two authorities briefly on that point, i.e. the interrelationship between a statutory provision specifically regulating fairness and the interposition of common law fairness, or the drafting on or grafting on of additional common law requirements of fairness. The first is the very well-known passage from the speech of Lord Reed in Wiseman and Borman, behind tab 6 in the authorities bundle. And the bit that we would invite you to read, if you would, I hope has been sidelined in the versions of the authority that the court has behind tab 6, page 308 of the law report. And it's the bit between B and C, starting with the second sentence of that opening paragraph in Lord Reed's judgment. So a recognition, of course, that the courts have regularly in the past, in appropriate circumstances, supplemented a legislative scheme if they thought it was appropriate and necessary for the purpose of giving effect, for example, to natural justice.
This was a tribunal hearing.
It was, I think, in context. It was the,
Yes.
yeah, it was the tax tribunal. And the passage we particularly rely upon is the final sentence of that paragraph, the but, the limitation which the courts have imposed on doing that.
This is in support of your argument that Section 13 standing alone is sufficient. How does that apply when the regulator itself has acknowledged that it needs some form of supplementary procedure, such as we have here, where the regulator in its complaints procedure says that it's useful, it provides learning experience for us, and presumably the complaints procedure generates results from time to time?
Complaints procedures can do, and many organisations have them. That isn't to be taken, I respectfully submit, or will submit, that isn't to be taken as a necessary component of fairness prior to the finalisation of the report. All of the incidents that my lord has identified can perfectly happily coexist with a process which is otherwise fair, pursuant to the statute and pursuant to the handbook.
Section 13 concerns the procedure prior to the decision, whereas
Concerns the procedure prior to finalising the report.
yes, but it is supplemented quite extensively. Well, would it boil down to this, that it's relevant in analysing Lord Reed's formulation that the regulator itself considers that there needs to be some form of supplementation?
Well, that slightly begs the question, which is whether or not the scheme prescribed in the statute that needs to be followed prior to finalising the report is itself and without more fair.
So on your analysis, Ofsted could withdraw its complaints procedure?
They could, without jeopardising the fairness of the process leading up to the finalising of the report. You'll appreciate that in the end I'm going to make two submissions. One of them is that when you take all the procedures into account, they were fair anyway, despite a potential overlap between the complaints process and what went on before, which wasn't just, as we see, the statutory process, but a whole handbook dealing with how inspections are to be covered and dealt with before you even get to the stage of a draft report per section 13. But secondly, and in any event, even if you take into account the complaints procedure and the opportunities it affords, in those rare circumstances when the complaints process, as it were, overlaps temporarily with the process leading to the finalisation of the report, there's no cause for concern on the facts here, because the submissions that were made, the points that were raised by the school, insofar as they impacted upon the finalisation of the report, were raised under the Section 13 process on, I think, the 13th of January, and there was then an initial, what purported to be a stage 2 complaint, I'll come to the characterisation, it may not matter, on the 20th of January, and both of those documents, to the extent that they didn't overlap, and largely they did, were in fact considered by the relevant people involved in the finalisation of the report. So it's going to be a submission both principled and on the facts. I should probably sit down now and made the submissions, but that's how the case is going to be put.
We rather thought it might. We rather thought it might.
Yes. So that's section 13. I was on Wiseman and Borman, I just wanted that passage. And then in tab 9, Lord Justice Dyson in Hillingdon. And again, a slightly different context because this involves consultation and duties being grafted to suggest there was a duty of consultation where the statute hadn't provided for one. You see that the context from powers 1 to 4 in the judgment of Lord Justice Dyson was a challenge to the increase in court fees for certain types of family proceedings. And one of the grounds of challenge, if you go forward to paragraph 22, was as to the scope of consultation. And if you go through to paragraph 35 from there, you will see that local authorities were not consulted, and it was accepted there was no statutory duty to do so. Indeed, as one sees from the relevant statutory provision in fact imposing the duty to consult, there were a series of named people, mainly eminent judges, who had to be consulted about that sort of change. And that didn't include the claimant, so they were asserting, as it were, a consultation duty to be imported as a matter of common law outside the range of consultees identified in the relevant legislative scheme. And the dispositive paragraph, so far as that is concerned, if I could invite you simply to read it, is paragraph 38, but it's on the same theme.
Well, can I just take you up on this? Because there may be different reasoning between the Wiseman case and what Lord Justice Dyson was saying there. If we go back to Lord Reid wasn't saying that because Parliament has specified a procedure, therefore the common law is ousted.
Certainly not.
What he's saying is two ways. He says, well, first we've got to decide that the statute procedure is insufficient. So you've got to make up your mind up. The court has to make up its mind that the statutory procedure is indeed sufficient to achieve justice. The second point is that, and this is, I think, a statutory implication, you can't introduce some new procedure if that would frustrate the apparent purpose of the legislation. I suspect that's a kind of a statutory implication of some sort. It's contrary to the intention of Parliament that should be done. So it's not simply a case of saying, well, because Parliament has laid down the procedure, therefore that's sufficient. There's more to it than that. You're agreeing with that, as I understand it. Yes, all right. So I say we understand the basis for this. And now, when we look at paragraph 38 in the Law Society case, Lord Justice Dyson seems to be saying that where a procedure is laid down, and I'm taking here the bottom of the first page of paragraph 38, Parliament is presumed to consider that the degree of consultation was sufficient. So I'm not quite sure it's exactly the same reasoning as Lord Reid.
It may not be quite the same, and I'm certainly prepared to accept that, but the word used is presumed. So again, it isn't an ouster, and it's and it's a different context because it's here, it's consultation. And as my lord will be very well aware, a duty to consult arises in only limited circumstances, where a statute imposes it, or where there has been a legitimate expectation created, whether by conduct or by express promise, that there will be consultation. And I suspect that the point that was being argued here was that the common law should import, in effect as a matter of fairness, an additional duty to consult a certain category of consultee. And the reasoning of the court is, well, I may not be entirely closing the door on the possibility of the common law grafting on a duty to consult in an area where Parliament has already prescribed certain types of duty. For example, if a promise had been made to the local authority, it would be the common law that overrode the presumption through legitimate expectation. But the grounds for doing that are very narrow and very and carefully prescribed by the doctrine of legitimate expectation, which is dependent upon a promise. What you can't do, certainly couldn't do, was override the presumption in this case simply by saying, well, it would be a bit fairer if. So it is on the same theme. One could put the matter a slightly different way, perhaps, which is to say it is highly relevant.
Yes.
To put it at its lowest, it is highly relevant that Parliament has addressed its mind to issues concerning procedural fairness. And it will, I'm not drafting a principle, but it will take quite a lot. Presumption, insufficiency, to use the two words from the two cases I've taken you to.
I mean, I think, yeah, I'm sure what you say seems absolutely right, but it must be a relevant factor, highly relevant, that Parliament itself has considered what would be procedurally appropriate.
That's probably enough for this, because then one can argue about the nature of the exceptions in individual cases. But there is some burden. I'm sorry.
An exception identified in the last couple of lines of paragraph 38 is an established practice by the decision maker.
I've forgotten that, but yes, that's LE. That's legitimate expectation. Exactly so. And normally in those cases, as my lords will be well aware, the argument that I face, given that I'm normally opposing a wider consultation, is based on past practice, and then you get sucked into Lord Wilson and Gaines, Cooper and Davis saying that if it's practice you're relying upon, it's got to be equivalent to a promise. But yes, that's legitimate expectation.
Yes.
Those are the two cases. It's also important and necessary to bear in mind, perhaps here, particularly given the references in Wiseman and Borman to at least cutting across the statutory scheme which is set up, that the process of preparing, finalising and publishing a report in cases of serious concern is intended by Parliament to be a speedy one. See, for example, the words without delay, which I emphasised in section 13 of the 2005 Act, and see the 5-day prescribed periods set out in the 2005 regulations, firstly for comments, and then for making available the report following receipt. And so Parliament has therefore set, it might be thought, a careful balance between ensuring that schools that face potentially serious consequences are given a fair opportunity to make representations prior to the finalising of a report, and ensuring that the serious grading is made known to, amongst others, parents pretty quickly. And again, what that tends towards is is not requiring any other layer of process beyond that which the statutory scheme provides for. One can put the point that I think we discussed earlier on in a slightly different way. If the complaints process didn't exist, it wouldn't be necessary to invent it.
Well, this, of course, is only in relation to those cases where special measures are needed.
Yes,
Because it's only in those cases that you have this particular procedure laid down by Parliament.
that's true.
So you would still need some other mechanism
You would,
for other cases.
which could no doubt be grafted in by the common law to fit the circumstances. And as I'm immediately about to go to, such processes exist in the form of the handbook. Can I turn to that? The handbook you will find in the supplementary bundle. At tab 1. the August 2016 version, as you see from page 1 at the bottom, so months before the inspection in question, which was, as you recall, the end of November and the beginning of December of that year. And it includes, is going to be the basic and fundamental point, it includes a series of procedural safeguards relevant to the fairness of the process by which the findings and the judgments in the report are reached. And you will see that it's a lengthy document. If you go to page 3, its purpose is set out in paragraph 1, describing the main activities undertaken during inspection, setting out the evaluation criteria that are going to be used when inspectors make their judgments. And the judgments we saw, the bulleted judgments we saw, and on which they report. Handbook has 2 parts. Part 1 is obviously the one that's most important for our purpose, but let it not be lost that this also sets out so that schools are well aware of the nature of the exercise and the judgments that the inspectors are considering, which is obviously relevant to the safeguards as you go through the actual inspection safeguards. But just focusing on part 1, there are, we submit, 3 layers, in effect, 3 layers is perhaps a convenient summary of it, of safeguards set out in this handbook that are relevant to our case. There are safeguards that apply first during the inspection, and these are safeguards that apply in all cases. So 1 and 2 are going to be safeguards that apply in all cases, and 3 is going to be additional safeguards where there is cause for concern. So safeguards during inspection, all cases, if you simply, perhaps one ought to note in passing paragraph 5, handbook applying to all schools to be inspected under the 2005 Act, and the schools subject to inspection include, as you see in the 5th bullet point, academies. Just going to the safeguards that apply during inspection, or before inspection, you will see that the heading before inspection sits above paragraph 28 on page 9. And it's informing schools how the thing is going to be done in a nutshell. That's the subject of paragraph 28. And then there is a requirement on inspectors to plan and prepare, unsurprisingly. But the purpose of this document is no doubt to ensure that schools understand what will inform the planning. See paragraph 29, the final sentence before the 4 bullets at the bottom of page 11. The planning will be informed by an analysis of, so they know what they're going to be particularly interested in. Then just spinning through it, para 33, notification and introduction, above para 33 as a title. It tells them the process and the initial information, how it's going to work and what the point of the initial call is, see para 37. They know what information is going to be requested at the start of an inspection because it's set out in paragraph 38. And then one can flick forward, I think, to the title above paragraph 51 on page 18, seeking the views of registered parents and other stakeholders. That's got to be done during the inspection, in effect implementing the Section 7 2005 Act duty. And in particular, they will seek the views of parents through something called Parent View, an online thing, para 52. And they'll seek the views of staff and pupils through online questionnaires, see para 57. So this is all setting out the process for gathering the evidence, and it obviously supplements the processes for gathering evidence. I don't need to go through the detail of it perhaps, but there are various processes for gathering the evidence set out in 61 to 67 and 77 to 84 of this document. So you see the gathering and recording of evidence dealt with at 61 to 63. Everyone knows the nature of the process. And then coming more directly to the engagement with the opportunity that the school has to feed back. Look at 67, if you would. Got to offer feedback to teachers. And then 69, if you would cast an eye down that. And note para 70, after a joint observation and so on, the lead inspector and the head teacher carry out joint observations and discuss strengths and weaknesses. Go forward to 87, there's a requirement on the lead inspector to meet the head teacher regularly throughout the inspection for the purposes that are there set out. That's obviously an important paragraph. Update of emerging issues, allowing him to raise concerns and alerting the head teacher to any serious concerns as they develop. Then para 90, if at the end of day 1 or during day 2 there's the possibility of a bad grade, then the head teacher's got to be alerted to that possibility. And then 92 and 93 make provision for a final feedback meeting, still during the inspection, detailed feedback. And you see the nature of it from the bullets over at the top of page 26. And if you then look to 93, during this meeting the lead inspector will ensure that the head teacher and governors are clear about the provisional grades awarded for each key judgment. Remember we saw those in the bullets on the first page of the final report. 93 I'm in now. Sufficient detail must be given to enable all attendees to understand how the judgments have been reached, the governors to play a part, and then ensuring that the head teacher and governors are clear that the grades are provisional, so may be subject to change as a result of a quality or quality assurance procedures or moderation. So those are the key features of it during inspection. Following inspection is the second category. And again, this applies in all cases. And I'm going to skip, for that purpose, I'm going to come back to the 95 to 108, because that's what happens in cases of concern. But just going ahead to all cases, post-inspection, 110 on page 30, or 109, the lead inspector will draft the report and the report is then proofread. The school is then sent a copy of the draft report to make comments, including but not limited to factual accuracy, see para 111. And the lead inspector will then consider the comments and make appropriate changes as 111 makes clear, and the school will then be notified of the response. And it's only after that that the report is finalised, see 113. We've got intensive engagement in all cases during the inspection with alerting of problems that are arising, feedback with teachers, feedback with the head teacher, the involvement of the governors, all of that. And then you have their involvement in the draft report and the ability to comment on the drafts about factual accuracy or other matters leading up to the finalisation of the report. And then if you go back to 95...
Can you just...
Yes, I'm
what's meant by paragraph 110, inspection reports will be quality assured before the draft is sent. What's the substance of the quality assurance process which is applied at that point?
I'm told it's mainly, if not only, proofreading.
I see, right.
I don't think there's much in that, but there's we'll see, there's quite an important additional element in there in serious cases.
Yes.
So that's the third area, additional safeguards in cases of concern. and that's dealt with in 95 to 108. You go back, schools causing concern, you see the title above 95. And then just to spin through those quickly, if I may, 96 to 98, the lead inspector has got to, during inspection, has got to check the possible judgment with someone who is one of Her Majesty's inspectors, that's HMI, at the regional desk, who will be independent of the inspection and normally more senior. (101) setting out when a school requires special measures. And providing for special words to be used where that is so. See the second bullet in 101. Again, subject to moderation by Her Majesty's Inspector, and in the case of special measures by Chief Inspector. 102, implications for a school causing concern. The timescale for moderation in a nutshell is extended. And there is some witness evidence in relation to this, and I'm just going to give you the reference, if I may, so you can write it next door to those paragraphs if you would. See also Sheridan 2, which is in supplemental bundle tab 15. At paragraph 82, which explains that in London, enhanced moderation includes an evidence-based review by an HMI, 2 further reads by an HMI and a senior HMI, and a final sign-off by a regional director.
So those are not in the handbook, right?
They are those are not in the handbook, I think that's right. That's 101.
Is that what's meant by moderation
Yes.
in 101?
Yes.
That's the substance of it.
That's the substance of it.
Would that be normal practice, that you may have potentially 4 other people expressing a view?
On cases of this seriousness.
Yes, anything falling within this category.
Yes. So those are the
That's
safeguards.
just London, but under 101, simply moderation. And there are no layers of moderation. Numbers of conditions.
I don't know what the position is thereafter. Maybe it just restricted. That was the subject of this grade.
I'm not sure. What is that? I'm just trying to understand this. In every case, as you've taken us to, everybody has the option of seeing the draft and commenting on it.
Yeah.
But that isn't moderation, is that right?
That isn't moderation. I think moderation is a separate process of putting it to a person outside the inspection. So the commenting on the draft in all cases is a commenting on the draft which is then considered by the inspector who does the inspection, the lead inspector who does the inspection. And in serious cases there's this additional layer of in effect someone outside it casting an eye and considering whether the judgments are sound. That's the essential structural nature of it. And as we've seen, the finalising of the report is something of a watershed for obvious reasons. Once the report has been moderated and all comments of the school considered, the report is then finalised. And the effects of that are, firstly, that the final report is normally published, as 113 of this handbook indicates, typically within 5 days. It's only in exceptional circumstances that it will be delayed. And that's so whether or not a complaint or even a JR has been filed. And there are some cases in the bundles about the importance of the public interest in publishing reports and so on, and the reluctance of the courts to grant said injunctions or interim relief. Secondly, the sending of the final report to the school triggers the school's obligations under section 14 to send the report to parents and make it available to the public, see 115 of the handbook. And the final report officially marks the end of the, quote, inspection activity, as 116 of the handbook points out. And the DFE then takes over, the Secretary of State effectively then takes over and can start considering what action might need to be taken upon the final grades in the report.
So I'm just trying to catch up with you here. So once you send it to the school,
That triggers the obligations of the school under section 14.
section 14, that's to send to parents.
Yes.
Then you've got also here, and then you refer to the report, to the handbook.
I think it was 115. Isn't it?
So back to all cases.
Yes.
This is all cases.
And then you see 116. It marks the end of the inspection activity, effectively. Much legal significance to that, but it brings that part of it to a close. It's necessary for there to be some division, some finalisation, because the Secretary of State then's got to consider what action to take. That's the structure of the legislative scheme.
So the point is that under section 13(2), there's no requirement for any of this moderation. All it says is you've got to show the draft report to the school and take into account the comments that are made.
Yeah.
So that, in any event, is what's in the handbook for every case anyway.
Yeah.
So it's the handbook that
Which
provides the extra layer for the school's cause of concern. And the first of those is that during the actual course of the inspection, there's an obligation to contact the regional duty desk and to inform, for the lead inspector to inform the person of the desk of his or her emerging thoughts and what the evidence is. That's 96, 97.
Yeah.
That's the and then there's where that is I think an obligation under this. 98 is a possibility. You can contact the regional desk again in the second day.
Yeah.
But if you have formed the view by the end of the second day that the school has serious weaknesses or requires special measures, then you must telephone the regional duty desk at that point and explain your position. So that's the first bit. I may have missed it. So what was this? Was there any other additional element apart from that, over and above the statutory requirement?
There are then the specific words to be used in the final feedback session, C101.
So that's to use that, but that's not a moderation.
Yeah.
Is there anything? But is there anything else? Just so I've got a clear impression of what the additional layer is.
Yes, and then the timescale for moderation may be included, but the big one, I think, is the introduction of the additional moderating layer.
Are we talking about, is that 90, is that 96, 97, 98, or is that something else?
No, it's 101.
That's 101. Is it information you're giving?
Well, it's also the moderation referred to at the beginning of 101.
And is that what Mr. Sheridan refers to in paragraph
Yes.
22?
Yes, that's the link.
And
It is subject to moderation. So I see that they're telling them it is subject to moderation. But
Yeah.
what is that?
Well, it goes...
I'm trying to find out. Is it all right? Say, is there anything here that specifies how that moderation takes place?
I don't think in here there is anything which specifies the detail of that.
Right.
it's simply a reference to moderation by Her Majesty's Inspectors, HMI, in the case of special measures agreement by Her Majesty's Chief Inspector, HMCI.
There's an additional layer of confirmation by the Chief Inspector and Delegate.
Exactly.
For special measures.
Exactly. And that, it might be thought, is probably the key one, because the rest of it is informing the school about that. See the bullet point that is
Is that here? Right. Section 13.
So it's two levels of HMI involvement. There's the on-the-spot contacting of an inspector to discuss the evidence on day one and or day two. And then there is, once that's gone through and the report is prepared in draft, there is the moderation through the HMI inspector. Moderation means an independent review of the evidence.
effectively.
So but paragraph 82 only relates to London. We don't know what moderation means otherwise.
I'm afraid I don't on the evidence for you.
If that's typical, then there's two levels of HM inspector, a review of the evidence, ongoing, and then fuller once the draft is prepared.
Yes.
And is it only in the case of special measures or schools giving cause for concern that the Chief Inspector reviews the matter?
Yes.
It's only in those cases.
Yes.
And we get that from these words in 101.
We do. And 102. It's those two paragraphs together. They're slightly muddled up because 101 contains also the words that you give to the school, and 102 deals with extensions of timings.
So it's by implication.
Well, it's by express words in 101. And my Lord, it may be important, just because I know my Lord used the word obligation, I quite understand why you did, but the nature of this structure is there are the statutory provisions,
Yes.
they impose legal obligations. This document is properly characterised as policy. As a matter of public law, it's a policy promulgated by a public authority, and as such, the public law obligation that attaches to the things that it says will happen is an obligation to do them unless there are good reasons not to. Does that make sense? So it's a softer form of public law obligation, which isn't the same as an absolute obligation, because you can depart from it if there are appropriate cases. The significance of that doesn't matter for present purposes, because these things were done.
Would it be fair to say that Mr. Sheridan takes the view that this extra statutory policy is an essential? He doesn't put it in quite those terms in paragraph 82, but it's not far off it. In terms of coming back to the question whether section 13 in and of itself is sufficient, or whether you need some common law interjections such as Ofsted has, paragraph 82 is quite a strong endorsement of this policy of ensuring an in-depth quality assurance for these special cases.
Well, my Lord, I quite accept that, and for no doubt for obvious and good reasons, Ofsted has turned its mind to the nature and detail of the process in order to try to make its inspections strike the right balance between effectiveness, not wasting everyone's time, happening quickly, and fairness. And so it's unsurprising perhaps that it comes with that endorsement. What I wouldn't perhaps, I think accept, although it doesn't matter for purpose of present cases, is that he is thereby accepting by implication the insufficiency of the legislative regime. But the fact of the matter is that this exists and this process was followed. That's the critical fact for present purposes. So the precise characterisations as to whether or not the handbook, I've already said that the complaints policy, if it didn't exist, wouldn't have to be invented. There may be a nicer question as to whether or not, which I think is the one my Lord is on, as to whether or not if the handbook didn't exist, it would have to be invented. But we don't need to worry about that, because it does exist and it was followed. Just in case at some future case someone turns around and says, well, you accepted when Lord Justice Green asked the question. This was an absolutely essential part of the common law fairness. I mean, that would turn, if that were right, one would then have perhaps nicer questions about the precise nature of some of the ingredients within this policy, whether they were harder-edged obligations necessary for the purpose of giving effect to the overall public law requirement of fairness. But those are issues perhaps for another day. Just to show you, if I may, the complaints policy. That's in tab 3 in relevant form. It was updated in 2017 after the relevant inspection here. You have the 2017 one at tab 2, but no, I think terribly significant changes. But I'm going to go to the 2015 one because that was the complaints policy in place at the relevant time, having been published, as you see from page 83, in September 2015. And you see paragraph 1, the focus is on complaints or concerns about the actions or conduct of our staff. See para 1. And there are 3 steps or elements to this. Step 1 is an informal resolution of conduct complaints during inspection. That isn't a step with which the JR was concerned, and it's provided for in paras 5 to 7, as you see. Step 2 is the making of a formal complaint, as the title of paragraph 8 indicates. And you see the nature of it, perhaps the 2 key paragraphs, which I'm sure we would have sidelined anyway, but you might just cast an eye down at paragraphs 13 and 14 on page 88.
The only reason given there is for not applying step 2 is because judgments are subject to the extended quality assurance procedure that you've just been describing. That's the only justification, isn't it?
See the penultimate sentence of para 14. Once the report has been finalised, any complaints about inspector conduct or the inspection process can be considered under step 2 of this policy. And 16.
So the way this operates is that once the report is finalised, it's at that point that the complaints procedure locks in. Really. Apart from step 1.
Yes, that seems
leaving
to be
things
the
up step 1.
intention.
So
Finalised, then the complaints go forward.
but it looks as though, as in fact happened in this case, if you make step 1 is pre-publication, isn't it? Effective, because it's during the course of inspection.
Yes.
So it's slightly unusual overlap. So the complaint procedure step 1 is really part of the pre-publication resolution of challenge. Step 2 and step 3 are post completion of the report.
Which they're meant to be, although in fairness it's right to, you've seen para 13, and there's something of a muddle up, because that appears to be envisaging the possibility at least, exceptionally, of withholding publication. But the intention appears to be...
That's not inconsistent with after. I mean, there could be a period where perhaps it's finalised, but not yet published.
That's true.
That's what I was thinking.
That's true.
But anyway,
that seems to be the basic idea.
That's the basic idea. And the broad distinction they're making in 14 is in the case where the school has required special measures or the judge to have serious weaknesses, because you've got this extra protection at the pre-publication stage, we're not going to revisit that same process again here, but we will in other cases. That's the structure.
That's it in a nutshell.
And just so it's clear, the last part of paragraph 14, which refers to complaints about inspector conduct or process, so if you like procedural objections, can those be taken under step 2 in relation to serious measures cases?
They can, or they can also be taken, as you know, by way of feedback and comments.
Understanding, but the distinction here is between judgments, as you like, on the merits
Yeah.
and other sorts of matters. So judgments on the merits can't be taken in step 2, but other matters can, even in relation to these very serious cases.
That appears to be.
But not findings.
Not findings.
But not, yes.
But again, I suspect there's a danger of too minute an analysis of a policy document of this kind. But the basic thrust appears to be, we'll deal with this afterwards. You've got special protection for special measures procedurally beforehand. Use that and don't bank on the report being pulled.
I mean, you say we of course, on the one hand, you mustn't examine it like some sort of detailed commercial document, but on the other hand, of course, as we see from this case, these things matter very much to the staff, the parents, and the pupils, and the public. So it is actually quite important that the structure is
Well,
clear.
I wasn't seeking to diminish the importance of it, but nor was I seeking to persuade you not to read it. And then step 3, you see set out in paragraph 21. That's the much shorter complaints document.
But now, step 3, let's see how far this goes. This is a review of process. Is that right? This is a review of the. I'm looking at 23. This is a review of process in handling complaints. So this isn't to do with, in a way, with the original report at all. It's to do with. I think it's to do with, leaving aside step 1, it's really to do with whether or not under step 2 the process of handling the complaint has been proper.
That's the normal rule, but it's subject to paragraph 24.
It's a review of the process of
Yes,
confirming.
which I think is consistent, because if I've understood it correctly, and it's quite complicated, but if I've understood it correctly, that the reason that exception is in there is because you've got that additional layer, as it were, that's confirming the inspection judgments. So complaints about those will be dealt with under this part, whereas they're cut out of, remember there was the cut out in step 2, and if you're complaining about that part of the process, you do it under step 3.
But it's all to do with process.
The 2017 guide is slightly different. Which is tab 2, paragraph. Step 3 is in slightly different terms, and I don't know if it's changed since 2015. Page 79, in tab 2.
The equivalent paragraph of 24 is 26 there, is it?
Yes, 24 says it's not a re-investigation of issues, but it will consider how we handle the complaint.
I think that's what I mean.
And then 26 is concerned with serious weaknesses. It says it will be carried out under step 3, and I assume that means it's a handling complaint again.
It's all about the process.
All about the process by which it was done.
Process,
Yeah.
I think, only for the confirmation of the judgments.
So in special measures cases, at step 2, you look at inspector conduct or inspection process. But step 3, the confirmation.
By the HMI lot, yes, the additional there.
And just so we understand, paragraph 27 of the 2017, is that concerned generally with all step 3 cases, or is it concerned only with serious weaknesses cases?
I'm being told all.
So that's the method. That would include a serious weakness case.
Yes. That right? I think that's all. All cases.
I think that would make sense.
So, I mean, at the moment it seems to me, I think this step 3 is not entirely clear, but in a way, 25 of the 2015 edition summarise it, because it says the review outcome, and I understand the review outcome to be for everything that's gone before, 21, 22 and 23, will be a final decision whether or not your original complaint was investigated fairly and properly in line with our published policy. I mean, that's how I'm reading this. Step 3 is not going back to the original report at all in a way. It's going back to the handling of the complaint process. Right, anyway, okay, fine.
Oh, I'm sorry, it's a complex system with some slightly fuzzy lines between bits of it, but I was going to turn to make the submission. Submission 1.
Yes.
The Ofsted procedures prior to finalising the report, and that is ultimately what we're concerned with, because the report was quashed, as you know. That was the target of the procedural fairness challenge. It was the process leading up to the finalisation. My submission is that Ofsted's procedures are fair without any reference to the complaints process. In principle, what procedural fairness requires, we submit in this context, is that the school should have a fair opportunity to participate in the inspection, and to make representations on the potential findings and grades in the report. And that duty was amply and entirely satisfied by the processes required as a matter of obligation by section 13 in the context of this sort of case, and the processes set out in the handbook that I described, the 3 types of safeguarding leading up to that finalisation. And frankly, if those processes are not enough to secure fairness, as a matter of common law grafted onto the statute or not, then quite a lot of public authorities are in quite a great deal of trouble. But that's the basic submission. That's a submission in principle, it's a structural submission. But there is no dispute here on the facts that the requirements of 13.2 were met. Or relevantly, despite some quibbling, as was clarified at the beginning, that the Ofsted procedures were otherwise followed, especially in relation to providing representations on the draft report. There were, just to give you a flavour, and I'll do it very, very quickly, there were, the process, in essence, you have the supplementary bundle to hand, the draft report, after all the processes that we've seen leading up to this point in the handbook were followed, the draft report was then provided on the 6th of January 2017, supplemental bundle 5, page 93. That is the draft report, and you'll see that it is pretty much as detailed as the final one. And the school and everyone else involved was invited to and did make comments on the draft report on the 13th of January. See the next tab, page 109. So this is the school's comments, which are actually dated on its face, but we think it's the 13th of January 2017. They comment on the detail of the draft report. And you see first of all the sort of points they're taking from page 109. The overarching points, they assert political interference, institutional racism and incompetence of the inspection team. But then there are some pretty detailed attacks and comments on the conclusions and judgments reached in the draft report, as one sees just from the nature of the document. And it goes on for 31 pages. There was a detailed response provided to those comments, I think by the first level of inspector, as it were, and those, the lead inspector, and those are set out behind tab 10. And that document, if you want to mark it on the top, we get this from the witness evidence, paragraph 19 of Sheridan 2. But that response was sent to the school, I think, towards the end of January.
31st, we didn't seem to have a letter. We didn't seem to have a letter on the 31st, which is referred to.
No, I don't think you do, I'm afraid, but that's what he says. Much turns on it. I'll see if we can get a copy if we need one. What this document does is to go through, point by point, the nature of the detailed challenges. And sometimes they're willing to make amendments in appropriate cases. There are examples of that from this document. And we submit that that process therefore involves the opportunity to make representations in detail, the sight of a draft report, all of this grafted onto the process we've already seen, the sight of the draft report itself, the opportunity to make comments which is taken up over 30 pages, and a detailed response to those provided before the, I think at the same time as, but the report is then finalised, but they're then taken into account. And we submit that that is more than sufficient as a process.
Is there any significance in the fact that this is described as a response to factual inaccuracies and factual inaccuracy check?
No, but I don't think so, because if you go through them, they're just simply responding to the comments. It's just the term that is used. I think anyone was suggesting that it was limited in some way in scope for that reason. There's no jurisdictional point taken. But in addition, what the school then does, or solicitors on behalf of the school then do, is to send to the Ofsted complaints team on the 20th of January a complaint. That's behind tab 7, page 141. And there is, in addition to points about publication and so on, there is significant, perhaps unsurprisingly, overlap between some of those complaints and some of those comments and some of those points being made in that detailed matter, and the comments, as you've already seen, submitted on the 13th of January. And ultimately it is that letter that is in effect responded to when the complaints process then goes forward and is concluded. But the interesting point to note, as it were, which to some extent answers the question about, or the issues surrounding structural interplay between complaints and Hamblen, is that this letter was in fact considered by the HMI moderation team prior to finalising the report and as part of that moderation process. So no, as it were, no, on the facts, no jurisdictional point is taken. Well, that's a complaint. We can't think about that until afterwards. The points that were made here were sent to and considered as part of the moderation process. And we see that from the next tab, tab 8. See the second paragraph of that email. So not going to, you get the point, and see the final paragraph, or that whole email is of interest. Well, I don't want to divert into it unnecessarily, but you've seen that there's an application to adduce some further evidence, all in it, and my learned friend is content with this to be referred to debenies if necessary. Our position is not to oppose it, but not to consent to it. I don't think, frankly, we really need it, because we have plenty enough in the 23rd of January email.
That's saying what's going to happen.
It did in fact happen, is the...
Your skeleton 35.1 says that's made clear by the letter of 31st of January, which we don't have.
You don't, but that is in the, I think it might even have been an email. So it's in, yeah. But there is confirmation that it did in fact happen.
We have to have the letter.
My lord, having made inquiries about the... I hope you don't mind, Sir
Yeah,
James.
sure.
Having made inquiries about the letter of the 31st of January before, my understanding was that it was in fact the letter of the 30th of January, but which was in fact sent on the 31st.
So the response to the comments on the draft report were attached to that letter.
That was 155. We'll see if we can't get greater clarity on that. But
That does make sense.
yeah.
That sounds right, if you look at the letter of the 30th.
As I say, if you wanted confirmation, there is also an email. It's all happening on the 30th of January. There's also an email from the higher-up inspector, as it were, the moderating inspector, confirming that the complaint submission, as well as the comments that we saw in the response, had been considered as part of that process.
Where's that?
That's attached to the short supplemental statement.
Oh, I see.
I don't know whether you've had that. Have you got? I'm not sure. Is it in the bundle? Okay. Can I just hand that up?
So what is this document now?
This is the application to adduce further evidence, and all it is a short statement that effectively attaches an email saying he did in fact do the thing that he said he was going to do. I'm sorry for that. The guts of it are in paras 3. Just trying to make sure there isn't any misunderstanding about what was said earlier. 4, 5 and 6 of that statement. And it attaches the email that you see attached.
Right, that makes it clear.
Does that make it clear? And I don't think it was ever, in fairness to my own friend, I'm not sure it was ever suggested that they didn't do what they said they were going to do.
No, but the documents didn't show me.
No, they didn't, and I agree that 31st of January.
What's happening? Is this an application that's supposed to adjudicate?
Well, I don't think it's opposed. It's not quite consented to, but it's...
My lord, I didn't want it to be implied that I was agreeing that any of the Ladd and Marshall criteria were met, for example, in relation to this evidence, so that it's crucial to the outcome of the case or any such thing, but I don't have any
You're not
objection.
really objecting.
No, my lord, I'm not.
I think we'll formally allow the application.
Grateful.
Thank you.
So that's the position on the facts. And the learned judge's judgment on this, so far as this first and main ground is concerned, is in the core volume. So if you put the supplemental one away, the core volume at tab 8. Just to flip through the key paragraphs, you'll see he expressly sets out at paragraph 15, section 13 of the Education Act that I've taken you to. At 16 to 18, he sets out the complaints or summarises the complaints procedure. What he doesn't do is to recite any of the provisions of the handbook which you've seen, although the handbook was before the court and relied upon. At 37 and 38, he records the representations, the fact that representations were made on the 13th of January, you've seen those, and the 20th of January, that's the complaints letter, and refers to the quality assurance process, and records that Ofsted responded to the comments of the 13th of January and made changes to the report. And you know that those facts occurred pursuant to the process set out in the handbook. And then the key paragraphs for the purpose of this, which enable him to not have to determine all the rationality arguments and dispose of the case on procedural fairness grounds, the key paragraphs are 46 and 47. And you won't be surprised to hear the submission, which I can make very shortly, which is that the critical flaw is a failure to give any consideration to the ability to do precisely the thing that he says is needed to be done, namely to challenge the substance of the draft report in advance of its finalisation. And that is because he doesn't cite from any of the processes set out or safeguards set out in the handbook, and doesn't indeed appear to consider anything apart from the nature of the complaints process, which is not integral to the finalisation process. That finalisation process is entirely fair because of the combination of the statutory duty in section 13 and the detailed procedures which were followed set out in the handbook. And for good measure, as you know, we submit that if there is a bit of an overlap between the two, and there's something in the drafting of the complaints which may suggest there may be in some cases, the fact is that the additional moderation there considered any of the substantive points and all of the substantive points that were raised under the banner of complaints rather than handbook comments. And so for the judge to say at paragraph 47 critically that there has been no ability effectively to challenge the report, we respectfully submit is simply wrong. Submission 2, I can take much, much more shortly. You will see, staying with para 47 of the judgment, what he says about judicial review. He says, in effect, that the fact that the school can JR the report does not make the question of the complaints process limit academic, because of the constraints of a Wednesbury challenge. But of course, the first point to make about that is that the limits of a Wednesbury challenge are constitutionally principled and proper, because they recognise that public law does not confer a role on the court of primary decision maker, but rather one of review, and the primary judgment is therefore for the person with the judgment conferred upon them by statute. But it is more important, if for present purposes, that sort of point, unrelated to procedural fairness and the requirements of procedural fairness.
It doesn't really matter whether it's wide or limited, it's just irrelevant.
It's totally irrelevant to the reasoning. The process is either fair or it ain't, and we accept that. And so submission 3, that's submission 2, and submission 3 is that the complaints procedures do not undermine the fairness of the Ofsted procedures leading to the finalisation of the report at all. And I make 3 short submissions under that banner, if I may. But firstly, the process is and was fair without it. Schools in serious cases can make any representations they like prior to finalising the report. The process was in principle fair, and it was fair on the facts. Secondly, even if the complaints process was in some way flawed, because of his analysis of stage 2 and all of that, the only effect that would have when you come to consider and make judgments about the fairness of the process leading up to the finalisation of the report, the only effect that would have would be to reduce or extinguish the contribution that additional layer of process might otherwise make to the fairness of the process. It doesn't in some way erase or render irrelevant or uninteresting all of the other opportunities that the school has already had. Thirdly, against us, it is said, well, having voluntarily provided schools in less serious cases with the opportunity to challenge judgments at step 2, it's not unfair, sorry, it is unfair, they say, not to provide the same opportunity in more serious cases, and it's then said that vitiates, therefore, the entire process by which the report has been created. But first of all, as we have seen, every serious case automatically triggers the enhanced moderation process. Which I've described. And it's because those cases are serious that this automatic, independent and senior review, effectively, occurs, taking account of all the representations made. And if the school had any points to raise, there was nothing to prevent them raising them in any event as part of that process. Whereas in less serious cases, there's no such automatic and independent review. And secondly, in serious cases, the enhanced moderations process, that additional element, is itself then subject to review as part of step 3, as you've seen. But none of that really touches the basic and fundamental point, which is that these processes are in any event fair, irrespective of the complaints process. What it can't do is to undermine it. And if and to the extent, as I say, that there is overlap, it doesn't matter, because what happened here on the facts is that they made comments, as they were entitled to do under the handbook. They made a complaint. To the extent that those were additional, they fed into the 2 layers of process that led to the finalisation of the report. And on any view, that is a fair process in principle, and we submit in fact.
And we're assuming here, because of the ambiguity about step 2 as to whether it covers procedural and or merits challenges, we're only looking at merits here because I think you agree that's the only thing carved out of step 2. Procedural objections can be handled under step 2.
I think you're thinking of the final penultimate sentences of para 14, I think. Yeah, which appear to suggest that.
Yes.
But as I say, the short answer to all of this Because you don't need the complaints process, you wouldn't have to invent it,
We have
but
to
in
work
any
out
event.
what it is that's said to be excluded. And as I understand it, it's only the judgments. In other words, the judgments on the merits. It's not procedural
It
objections.
isn't procedural, and then you have to grapple with the coincidence of timing, but the answer to that is effectively factual. Everything they wanted to say was fed in. There was no change to the 20th of January letter. When later they came to dispose of that under the complaints, it looks like the complaints are meant to be dealt with afterwards, certainly after finalisation. But in any event, all of that is neither here nor there. In principle, because the process without it is fair. And secondly, because on the facts, everything they wanted to say was taken into account anyway, as part of those processes leading to the finalisation. So those are our...
Yes, at the moment it seems to me that step 3 is an irrelevance to all of this.
It's all about
On
step
this
two,
case,
isn't it?
in this case, step 3 really is the feature. So step 2, it's step 2 that was the critical issue between the parties. Thank you.
Well, that's on that. I said
Oh,
I
I see.
would refer very, very briefly to a couple of disposal points.
Yes, you're right.
And so far as that is concerned, it might be thought there are two issues. It may be that there are further submissions that are needed after judgment has been handed down on this, but publication is one. Now I've got a very old report that has been languishing, unpublished, subject to an outstanding interim order not to publish. And there is a strong public interest we would respectfully submit in publication, reflected in the statutory scheme, and just because of the context, it's important that people should know about these views, even if they're being challenged. That leads to all the case law, and you're reluctantly, in extreme cases, granting injunctions. But if the appeal is allowed, then the procedural fairness challenge will have failed. What will remain is the possibility, which I'll come to in a moment, of remission to determine the irrationality conclusions. But we would respectfully submit that once and when and if the procedural challenge fails, then that fundamentally affects the balance that led to the imposition of the interim order precluding publication. And if all that is left is the possibility of remission for the purpose of determining irrationality, then that should proceed post-publication. At the same point, of a slightly crisper way, if the procedural ground of challenge fails, the claimant's procedural ground of challenge fails, that fundamentally affects the balance of interests.
I think we have the judgments in relation to the injunction granted.
No, I don't think you do. But
Well, there's nothing, there's no decided case that can assist us on that issue.
I don't think on that issue. There are some cases which are in the bundle, setting out the public interest and the strong public interest in the publication of Ofsted reports, unsurprisingly, and illustrating a reluctance in the courts to preclude publication pending the determination. Of course, it's open to the court on the usual injunctive basis.
That did happen in this case.
That did happen in this case,
What
but
was about this case that led to that?
well, again, I'm sorry, we haven't got the judgment, so we better get you that. But whatever it said, as it were, I'm sure it will have relied upon the seriousness of the allegations and the procedural fairness and so on. But what you now have on this hypothesis or on this premise is a rejection of any suggestion that this was a procedurally unfair process. And you would have seen from the judgment that the judge also rejected perhaps the most serious of the irrationality or factual bases, including conspiracies and all those allegations. He did actually reject some of the more serious of those. So you'd be left with the possibility of some further allegations of irrationality to set against that public interest. That's the issue that would arise. I don't invite you to deal with it now in your judgment, but it's something that is likely to be on the horizon if you're in my favour otherwise on this procedural issue. So I would like to flag it. The second thing that will be on your horizon is what you do about remission. and whether there is truly a public interest. And again, we haven't got all the authorities that may assist you in relation to that in the bundles already, but there are lots of authorities that go to the basic proposition that the court in a JR is entitled to refuse relief in circumstances in which it deems the proceedings to be disproportionate to the work that would be required to determine them, and so on, remedy being discretionary and judicial review. And there is at least a question as to whether or not it is truly sensible, given the developments that I outlined at the very beginning of my submissions, and given the rejection of some of the more serious rationality points that were made in the judgment already, is it really sensible for this sort of challenge to drag on? I mean, no doubt my
That's why you can put it that way, but there are a lot of people whose reputation is issue here. You've got the governors, you've got the teachers who are involved.
Well,
it's not quite so straightforward as to say, well, it's only rationality.
Well, my lord, that's true, but
If it stands, then the position will be that a lot of people who've served one way or another on this body over the years will have their reputations impugned by the consequences.
that's true, and I don't seek to deny that or say that the issues would be in some way entirely academic. There is, however, a broader principle that is available, even if there are live issues of that kind. Maybe we'd have to make further, more developed submissions in relation to this, which would include, no doubt, a focus on precisely who were subject to that sort of issue as a result of the report as it stands, which were principally, if I've understood it correctly, the management team who are no longer in place anyway. But there are issues there. I flagged them and no more. As I say, I don't invite the court to determine either of those two issues.
Well, I think we have to work out. I think we have to work out. You'll say about this. I would have preferred myself for the submissions on this to be made now rather than later. That would be my preference, so that we can then, when we publish our judgments, as it were, deal with the question of the substantive appeal and its consequences. But it sounds like you're saying you prefer not to do that.
Well, I think if you were going to do that, it may be that both parties would need an opportunity to put in something pretty short in writing. Because there are certainly cases I would wish to refer you to, or a case or two that I would wish to refer you to for the purpose of establishing the principle I just mentioned about proportionality. And it may be that there are other issues to do with publication that anyone else might want to refer to. But that could be done within a pretty short time frame.
Yeah, so I'm afraid I don't like people putting in written submissions afterwards. I mean, it may be, in some cases, they're short, but they're not always very short. And there are questions to be asked. Anyway, we'll see when we get to it.
Well, if you want something further from me, then I'm very happy to offer it.
But I gather that. Anything further? Yeah. Thank you very much. Yes.
My Lord, can I start backwards, please, just dealing with that point? It might seem rather odd, but since it's live. My Lords might have noticed that I tried to flush this point out in my skeleton argument when I first noticed that there was a missing reference to remittal, and it hasn't been flushed out yet. And so it is very important to my client and to certain individuals that the report does not stand, and I would want the opportunity to make proper considered submissions responding to what Sir James has to say in relation to Richard.
So you're saying you don't want to deal with this now either?
No, my Lord, I don't. As we see it, there's permission being granted on the rationality ground. We didn't, the court will, and I assume, be pleased, we didn't put in a respondent's notice asking this court to uphold the order on the rationality ground, because at that point we understood that remittal was agreed. It may be that there can be discussions between the parties when their respective positions have been set out, but I wouldn't want to deal with this point on my feet now without having full information about the people who are affected. And of course, my Lord, there's also the issue of costs below.
Right. You're appearing, are you, on behalf of the Durand Academy Trust,
Of the
which no longer exists?
Well, it does exist, my Lord, and my understanding is it exists for more than simply conducting these appeal proceedings, which was, I think,
So
what-
anyway, it's an entity that still continues.
Yes, it's a charity.
So you don't want to deal at all with the consequences if we were to allow the appeal.
Today, no, my lord. I would rather make written submissions in response to my lord's judgment
Very well.
if the need arises. I'm grateful, my lord.
Well, I'm not saying I agree or I don't disagree. We'll have to discuss it between ourselves. But I understand you're both saying the same thing.
Well, my lord, I can perhaps take some further instructions over the lunchtime adjournment.
All right. Well, fine. But I don't want to hold you up now. So carry on with your other submissions on the main point.
My lord, if I may, I'm going to start with the facts, really, where Mr. Eady ended, and what it is we say was missing, and what it is we say was unfair about the process, and then I'll move on to the legal submissions as to how this all fits in. The court is aware that the complaint relates to stage 2 of the complaints process, which we say provided an opportunity for some, but not all schools, to challenge and potentially have reversed the substantive inspection judgments. This was not available to my client, and it's not available to schools whose interests are most adversely affected by the particular type of decision. And that is what we say is unfair. We say it's unfair for there to be a procedure which provides enhanced procedural rights, and I will get on to explaining why we say they are enhanced rights, not merely duplication. It's unfair for there to be a procedure providing enhanced procedural rights to those whose interests are less seriously affected than the others. So effectively the complaint is about being excluded from the right to challenge the substantive judgments under stage 2 of the complaints procedure. My lords have been taken to the various bits of the handbook which describe the procedure that Ofsted follows, and in particular what my learned friend describes as the procedural safeguards in a special measures case. We say that in order for this procedure to be fair, those safeguards would effectively need to provide what my clients were missing out from under stage 2. So, my lords, I'd like to take you, if I may, to have a look at the type of procedure that is provided by stage 2 of the complaints procedure and compare it with the quality assurance process that took place in this case. By way of background, as my learned friend correctly told the court, schools in all cases have the opportunity to submit factual accuracy comments and to make comments on the report judgment at that point. So that's not an enhanced process, it's a process that's available to everyone. Well, what is different is the quality assurance process that my lords have seen some of. But if I might start with the complaints procedure and what in fact consideration of a stage 2 complaint involves. First, if I might take my lords to tab 15, it's the witness statement of Michael Sheridan, tab 15, page 280. One paragraph, I've marked paragraph 118, my lords, which is not on 280, it's on 282. 118, he explains, and if my lords flick backwards, he is dealing from 280 with the refusal to consider a complaint, and he makes the point about delaying publication. But the point I wanted to make is at paragraph 118. All complaint investigations are undertaken by an inspector with no previous connection to the school of inspection being complained about. The school made representations which the inspection team responded to where appropriate to their role in the inspection, and the evidence base is available for consideration. The investigating officer then weighs up the evidence from either side and reaches a conclusion wherever possible. And the evidence we have about what actually happens in a stage 2 complaint procedure is behind tab 12, my lords. And as my lords have noted, a school is entitled to complain about the conduct of the inspection under stage 2, but is not entitled to complain about the substance of the judgment. I might ask my lords briefly to look at this. If one turns to page 200, or page 199, we'll see he has had a conversation with my instructing solicitor. 200, in the middle of the page, as we discussed on the telephone, I have no mandate to consider the inspection judgments, as these have been considered when the inspection judgments were moderated. And then he says, in investigating your complaint, I have made detailed reference to the inspection evidence recorded at the time of the inspection, contemporaneous notes, etc. If I could ask my lords to read that paragraph and the following in summary. And then what my lords see on the following pages are his analysis by reference to the materials he has considered and the views that have been provided to him of those aspects of my client's complaint that he was able to consider under the stage 2 process. Now, my lords, for obvious reasons, don't have an example of the type of analysis that would have been undertaken of my client's substantive complaints about the inspection judgments, but I would submit that on the basis of this evidence and on the basis of what Mr. Sheridan says about how the complaints procedure works, what a complainant gets under stage 2 is a detailed and reasoned decision letter, a review of, on the basis of a review of all the relevant material responding to the complaints made. And that decision letter and the investigation is carried out by somebody who is wholly independent of the process of finalisation of the report. My lords, that I say is an entirely different exercise, at least on the basis of the evidence that has been provided to this court, from the quality assurance process. First, the letter, as I understand it, providing reasons at the end of the quality assurance process is the letter at page 155 behind tab 9. doesn't demonstrate any detailed engagement with the type of points that were being made in the complaint letter about the quality, about the inspection judgments made, and which in my submission one would expect to be provided if the complaint were permitted to proceed under stage 2. The factual accuracy check, which is provided along with the letter as we understand it, again doesn't engage with the detailed arguments about the substantive inspection judgment made. Furthermore, it's a response from the lead inspector himself, the person who reached the provisional judgment, and therefore is not independent of the process. So that is the only detailed evidence my lords have as to what actually goes on by way of quality assurance. I will refer my lords back to paragraph 82 of Mr. Sheridan's witness statement, which was at page 11. My numbering seems to have gone a bit wrong. Mr. Sheridan's witness statement, 82, behind tab 15, my lords, I'm grateful for that. And although my lords see a summary of what happens, and I'm not asking my lords to go behind that, I can't, but one would have expected, given that the issue was squarely on the face of the pleadings, that had this exercise generated any significant and relevant documentation as to the way in which these procedures were carried out, that would have been provided. What my lords do have this morning is the briefest of emails from one of the people involved saying that he has reviewed the relevant documents.
I'm just trying to understand where this is getting us to. The judge below found in favour of trust on the basis that step 2 of the complaints procedure was not capable of being a fair process because, as I put it this way, unfairly discriminated, as it were, against those who, those cases where there was cause for serious concern and special measures were required.
Absolutely, my
So
lord.
that's a structural point. Well, what actually happened in this case is a structural point.
My lord, yes.
What we've seen from the handbook is that, well, there are 2 points. One is section 13.2 says what it says, that the process, that the comments have to be sought and considered.
Yes, my lord.
It says that. And we've seen the handbook, and the handbook sets out certain other processes which it says as a matter of policy ought to take place as a matter of normal process, and they involve this moderation. Now, what you seem to be now doing is comment on what actually took place, as opposed to what ought to have taken place if the statute had been followed and the handbook had been followed.
Well, my lord, what I'm doing is commenting on what actually took place in response to my learned friend's submission, that effectively allowing a complaint of this nature to proceed through stage 2 of the complaints procedure is simply duplicative of something you have already had.
Well, I think something ought to have taken place. I'm just trying to establish whether we're talking about failures in what has actually happened, or, as I understood the judgment below, a legal point about whether something's capable of being a fair process. They're two, as I see it at the moment, two different issues. I thought, at the beginning we'd established that you weren't going to be commenting on alleged deficiencies in practice.
Well, my lord, what I am trying to do is to demonstrate in practice the nature of the procedure that is adopted under the handbook, and so that this is it's a general statement. This is what happens in practice, whereas in practice, what happens when a stage 2 complaint is investigated is something very different. And I would say that my lords need to look at the substance of what happens in order to decide whether excluding my clients, or discriminating, as my lord put it, against them by not allowing them to have that procedure is unfair.
Using the facts to illustrate why you say the procedure is unfair.
But yes, my lord, in response to the suggestion that it is a duplicative process.
Or putting it slightly different way, I think you're saying there's no reason to suppose that the facts here are different from any other case.
No,
That's I think what you're saying.
That is, I apologise for not having said it. That clearly, my lord, yeah, that is what I'm saying. So, my lord, that is the position on the facts, and as I've said, our position is that that complaints procedure is irrational, because when one looks at fairness, it is important to consider the nature of the decision complained of, and one would expect to see enhanced procedural safeguards for somebody who is more adversely affected by a decision, and instead here one sees the opposite. And we say that that is the starting point in this case, and I'll go back now to say how we tie that in response to Mr. Eadie's submissions. But we say the starting point is the unfairness on the face of the complaints procedure that deprives our client of the right to have that independent and thorough review of the substantive judgments. There is an important distinction between this case and cases such as Wiseman and Borman, in that in those cases the courts were being asked to supplement the statutory scheme by imposing a particular procedural requirement that was said to be necessary in the circumstances of the particular case. Here we submit the situation is very different, because Ofsted itself has supplemented the statutory scheme by making a number of provisions as to the procedure to be followed, including, as Sir James puts it, adding another layer of process. Now, while I accept, of course, that the statutory scheme is relevant, we submit that the relevant question in a case such as the present is not whether the statutory procedure is insufficient to achieve justice, but that focus must be on the procedure actually adopted in the circumstances of the case, and whether that procedure was fair and reasonable. And I appreciate that it's very different, but I draw an analogy with the situation where a public body decides to consult where there is no statutory obligation to do so. Such a consultation has to be conducted fairly. In our submission, when one looks at the handbook that Mr. Eadie has shown the court and the complaints procedure together, the complaints procedure is properly regarded as an integral part of Ofsted's overall process of A, reaching, and B, maintaining inspection judgments. I say reaching because in exceptional cases publication may be may be postponed under paragraph 13 that the court had seen, but normally in this particular context of challenge to substantive judgments, it will be about maintaining inspection judgments. And in my submission, that does not make this case any weaker. It is well established that fairness can require an opportunity to make representations against a decision that's already been made. And in this case, given that that opportunity was given under step 2 to those who are lesser affected, we say it's unfair for us not to have had it. And unfairness in that procedure leads, and rightly led, to the report being quashed in this case. So, my Lord, we say that that is the appropriate starting point. I've addressed the appropriate starting point is the unfairness in the complaints procedure and the denial of our clients the opportunity to challenge the substantive judgment findings. The delay point doesn't seem to be focused on. My Lords would have seen what I've said in my skeleton, is that it's absolutely clear from the procedure itself that delay is a distinct issue and can be dealt with separately under the procedure. That is not a rational reason for excluding a party from having the opportunity to make representations.
When you say delay can be dealt with separately under the procedure, what
Yeah.
do you
Well,
mean?
my Lord, there was a justification put forward, although not in the face of the procedure itself, on the basis that effectively too many people, if complainants in this particularly dire situation were allowed to bring a complaint under stage 2 of the procedure, it was suggested somehow that that would cut across the statutory scheme because that would delay the process of publication. And my point is that it's clear from the stage 2 procedure itself that Ofsted will not normally delay publication of a report. So delay falls to be considered separately from the question of looking into the substantive judgment findings made in the report. It doesn't provide a rational basis for, or a fair basis for saying that somebody shouldn't have the same opportunity as others to take advantage of the right to challenge those judgments. Did my Lord have a question for me?
I'm just thinking about what you're saying. So you're saying delay can't be a factor because Ofsted's normal policy is, even where it's considering a complaint, to go ahead and publish the report anyway.
Yes. Now, it may be, because of course it has a discretion and of course there are exceptional cases, it may be properly in the exercise of its discretion in some cases, weighing up all the appropriate factors including the statutory scheme, it would decide to delay publication. But that can't be a justification for not allowing any person in this position to make a complaint under the scheme, under the complaints procedure.
No, I understand what you're saying, but the expectation would be, as in this case is the fact, that anybody in the position who's facing the charge, conclusion, that the school is a matter of grave concern, needs special measures, will apply if they're challenging the report for it not to be published. And if they, Ofsted, decide they do want to publish it, you'll then be, as you've done in this case, applying for an injunction. So they could be faced with a whole series of cases where people are applying for injunctions.
Well, my Lord, they might be faced with those anyway if there's no opportunity to bring the complaint under this particular procedure.
So I was just focusing on your point that if if in fact they go ahead and publish anyway, what does it matter? But their concern is that they'll be faced with a flood of people who would say, don't publish. And the problem is there, I'm just trying to vocalise in my and rationalise in my mind what the position is. Their position presumably would be, as in this case, as in the case I did previously on the HHJ school, the first thing that happens is the school applies for an injunction.
Sometimes successfully and sometimes less. But
Anyway, I just wanted to just test that point.
No,
but I hear what you're saying.
my lord, I appreciate that is a possibility, but in my submission, that really might happen anyway, as indeed it did in this case, even though my clients do not have a right to make the complaint they wanted to make under Part 2 of the complaints procedure. So the fact of schools wanting to challenge reports and asking for postponement is not, in my submission, related to the fact that they might be able to bring a particular type of complaint under stage 2 of the complaints procedure.
I mean, your more powerful point is that if I have a fair procedure, you have to have your complaints dealt with properly.
Absolutely.
And you know, whether or not there's an issue about timing doesn't meet that point. It doesn't make a procedure which is otherwise unfair fair, just because there's a concern about publication. I think that's really the point.
No, it is, my lord, and it's a response to my learned friend submission that was in his skeleton, although I think not repeated already, that this procedure would cut across and frustrate the statutory purpose. It was a response to what I understood that submission to be, but in my submission it would not frustrate the statutory purpose for the reasons that I have explained.
Yes. The complaints procedure itself doesn't make a claim about delay, but it simply says the different procedure is justified simply because there is a different quality assurance procedure applicable to more serious allegations.
Yes,
That's the only basis upon which Ofsted seeks to justify the difference in the complaints procedure.
In the complaints procedure itself, absolutely, my lord, and I have, I hope, addressed that, and also the way that fits into the overall scheme. But might I have a moment to look behind me? My lords, there was a small discussion about the question of potential disposal behind me, but I wonder if I might take instructions on that with a little more time later.
Yes. Have you finished your submission?
Yes, my
Oh,
lord.
that was very brief. And commendably brief.
Well, my lords have my skeleton.
No, of course. Yes, no, I'm certainly not by any means complaining about it. Yes, leave the question of disposal for the moment. Absolutely.
Grateful, my lord.
Yes.
Labour efficiency. My lord, a pretty crisp in reply as well, I hope.
Yes.
You know the essence of our case. We essentially submit that the handbook plus the statute both complied with. They provide, in combination, a more than sufficient, certainly a common law fair opportunity to participate in the process leading to finalisation of the report, and that is effectively the beginning and the end of it. My learned friend says, well, there is a different process under the complaints procedure with emphasis on the length of the letter responding to the complaint that was ultimately made.
Yes.
We make 3 points about that. One, unsurprising that there is such a letter at the end of that process, because the essence of it is precisely to respond to the complaint, and it was needed to respond to the complaint, so you have a separate letter at the end of it. By contrast, secondly, the report and its conclusions are at the end of the process in which the school participated and which involved the moderation that you've seen. And the end result of that process is, for obvious reasons, the report. But for good measure in this case, as you've seen, it was the sideways document. They were sent at the same time, effectively, a detailed response to all of the points that they made in their 13th of January.
I mean, presumably you rely on the fact, I don't think, having briefly looked at this schedule that they sent, it doesn't say this does not fall within our remit to consider your comments because it's not a matter of fact.
No.
There's no
That blurs two slightly separate points. That sideways schedule, as I understand it, was a response to the 13th of January factual comments, or factual accuracy, or whatever it was. They then sent the 20th of January letter, and that letter didn't go to the lead inspector, if I've understood it correctly. It went to the moderation process, the next level up. And that led to the letter of the 30th of January, to which my learned friend took you, and said, well, look, by contrast, this is a jolly short letter, to which our response is, jolly short letter it may have been, but you got the report to the extent that there were overlapping points of substance made which went to finalisation. They were already dealt with in the sideways schedule. And by the way, no one took a jurisdictional point about the issues you raised in the 20th of January letter, which fed into the moderation process.
You could actually have taken all the points, presumably, in the 20th of January letter in the 13th of January comment document.
Yeah, there could have been. I don't know, I confess I haven't done the analysis to see to which
But
the detail
there's
overlaps.
types of complaint you can make in
Yeah.
relation to the draft report.
Are there,
Make a substantive.
Yeah. But that's how I was but I did ask in your opening submissions about the fact that it says response to factual accuracy check, and you said yes, but if you look through it, they're not just points of fact.
I think that's right. If you do, I hope that's right anyway. But there's no jurisdictional point taken in relation to that against what it says it's unfair because it amounts to factual things rather than other points. I mean, you saw the nature of the complaints that were being made, and think of the first page of the 13th of January letter itself, the one about political interference and institutional racism and all that. I think it's a response to the letter of the 13th of January. It doesn't seek to draw subtle distinctions between fact and law.
I mean, the way that the handbook refers to the process is will consider comments including details of any factual process.
Yeah.
So you can see how it's labelled like that.
Quite.
It's not limited.
It's not limited to. That's why I characterised it as no one taking a jurisdictional point. So that's the thrust of the submission that goes to, well, there's a different complaints process with a longer letter responding. That doesn't in any shape or form render the process that led to finalisation unfair, because it had its equivalents in that response to the 13th of January letter, even if required. But if you think of most of the circumstances in which this sort of issue is considered, the kind of DTI inspection reports, maximalisation, all of that, the feeding into that process, it's never been suggested that there's a requirement that you produce the sort of document that is the response to the 13th of January letter. You simply get an opportunity to feed into the inspector's report, to take that example, and they think about them and they then produce their report accordingly. There's no obligation of result. It's an obligation of process. So we respectfully submit that that contrast between the end result of the complaints process and the end result of the finalisation process is not a contrast that leads to a conclusion of unfairness. There is no need in any event for there to be equivalence in terms of the processes that, as a matter of policy or law, are required leading to the finalisation of a report and the steps that lead to the resolution of a complaint. You don't need them to be equivalent. And my learned friend then says, well, the starting point for all of this is it's jolly unfair, in effect running a discrimination argument. I mean, one answer to that is that fairness is about fairness in the process that you're considering and fairness on the individual facts. It isn't a good basis for saying someone treated me unfairly to say someone else might have been treated more fairly. So it isn't truly
The point is slightly different, that except that a serious case is not comparable to a less serious case. So in circumstances of a serious allegation, there are adjustments elsewhere in the system which are not applicable to the less serious case. So they're not actually comparable, directly comparable situations.
Exactly so. I was going to come to that, but that's a significant and substantive answer to all of this. However you package it, whether if one's analysing it in discrimination terms, whether one packages it under not in an analogous situation, or you package it under justification, may not matter terribly. The fact of the matter is that rational judgments have to be made about those sort of things when you're designing this sort of policy. And it's a perfectly rational view to take, to say, well, I'm going to treat that category of cases separately, precisely because, the point my law puts to me, precisely because there are additional processes in serious cases, and that's moderation.
Just in relation to that, I've noted the judgment of paragraph 42, which is a summary of Mr. Sheridan 82. The judge says that these quality assurance processes, which Mr. Sheridan is referring to in relation to London, are undertaken in line with quality assurance guidance published by Ofsted internally. So the judge takes it that paragraph 82 is symptomatic or typical. Do we have the internal guidelines, or is it common ground that what Mr. Sheridan is describing as these extra 3 levels of quality assurance is in fact characteristic and applied across the board? It's not just London-based.
I don't think it's just London-based. I'm afraid I have no idea why the reference to London happened. There may be some nuance in it that I don't know. I'm reluctant to start giving evidence about.
I was just looking at what the judge said in the last sentence of 42.
Of 42. Which would suggest it's a rather more general application.
Yes.
Oh, yes. Well, that's my understanding. But there may be subtleties of difference which led to the reference to London. But I don't know the detail of that. But well, in the end, we respectfully submit that my learned friend has to say that the complaints stage 2 process, which is not applied to her because of that additional moderations process, is a necessary component of fairness in the finalisation of the report, structurally, or in principle, to go to the distinction my lord, the Master of the Rolls, was putting earlier. And that is an impossible submission, I respectfully submit, precisely because, structurally and in principle, for one comes to the facts, it is open to the individual school to raise, as we've seen under the handbook and under the statutory processes, anything they wish, going to the judgment set out in the report. So it is structurally untenable to submit that you need the stage 2 complaints process dragged in. But secondly, and in any event, to the extent that this is an appeal which does delve into the facts, whether by way of example or illustration or otherwise, she would then have to say that as a result of that exclusion from an equivalent of the stage 2 process in the handbook or statutory processes, they were in some way, shape or form prejudiced, i.e. there was unfairness, because things that they would have been able to say under stage 2 could not be said and were not said under the handbook and statutory processes. And they can't say that in principle for the reasons I've just given, and they can't say that in fact, because we know that the 20th of January complaints letter was considered as part of those handbook and statutory processes. And that's the end of it. We submit. Well, those are my submissions in reply.
Very good too. I think what we better do is we'll rise now just to consider what we're going to do about the consequential matters, because we're going to get you back after lunch, it's not necessary. So we'll rise now for 5 minutes, have a quick look about that and come back to it.
Brilliant.